Good morning, folks. My note here says we have 5 hours of argument time. I don't think that's accurate looking at this room. Happy Thanksgiving to all of you and your families. I would love to get you all out quickly. So ask for the time that you need, not the time you think you need to educate us about your appeals, because I assure you, we are a hot bench, and I'm really interested in your strongest arguments as to why you believe we should find the way of your client. People versus Arcana. Submitted. Pavel versus Justice Center.
Morning, Your Honor. Harvey Fishbein. 8-3.
Counsel? 6, 2, and 6. Y.H. Lex Estates versus Meyer.
Good morning, Your Honor. Dan Rockstrike. Take the 6 and 2.
Counsel?
5 minutes.
5, 2, and 5. People versus Sproul.
Appellant requests 4 and 2.
Respondent requests 2.
4, 2, and 2. Countrywide? Submitted. Patterson versus New York City Department of Education. Submitted. Diamond versus TF Cornerstone. Now, there are 3 appeals here, so let's start first with Unity's appeal. Unity?
Yes, folks are for Unity, 7 minutes ago.
Okay, 5 and 2 for Unity. Who's opposing Unity's motion? Just plaintiff? Okay, so I will give you each 2 minutes. So it's 5, 2, 2, and 2. Okay, ABM. Sir?
4 and 1.
You got it. 4 and 1. Who's opposing? Plaintiff? Plaintiff. How much time do you want, plaintiff?
2 minutes.
Unity's opposing as well.
Okay.
2 minutes, Your Honor.
Okay, so plaintiff and Unity get 2 and 2.
Clear also is opposing.
Okay, so 2, 2, and 2, and then ABM, I'll give you a minute to respond. Okay, plaintiff's appeal. 5 and 2 for plaintiff. Who's opposing?
Defendants, respondents, TF Cornerstone, and Carnegie Hall requesting 4 minutes.
Anyone else?
Clear is 5 minutes, please.
Okay, so it's going to be 5, 2, 2, and 2. Okay? Have a seat, folks. People versus Javier. 5, 2, and 5. Channel Fabrics versus Sawerski.
Good morning. Appellant requests 6 and 2.
6, 2, and 5. CIT Group versus Star Surplus. 7, 3, and 6. 255 ADC Realty versus Popular Jewelry.
Morning. Appellant requests 5 and 2. Respondent, 4 minutes.
Very well, 5, 2, and 4. The next case, Steele versus Consolidated Edison. Anybody here? Submitted. I do want to note for the record that, what's that? Did I? Which one? Oh, excuse me, folks. People versus Norwood? Submitted. Steele, anyone here on Steele? That's submitted, but I do want to note that Justice Gesmer and myself are recused from that case, and Justice Rosado is vouched in on that case. And finally, Lane versus the city, submitted. Okay, folks, first argument. Counsel, you may begin.
Good morning, Your Honors, and if it may please the court. This case raises an issue of due process and also a substantial evidence claim concerning the determination by the Justice Center.
So is your due process argument that the charge, first of all, how are you notified that you're under investigation?
There's a letter that is sent to the subject of the investigation.
And what's in that letter?
That there's an investigation and the actual...
It was a very brief,
Very brief.
28 words, right?
The charge itself, yes, that's correct.
28 words. So your main point, is it not, is that the indication in that charge is that the service recipient is the one who's reported a claim, but in fact, as things emerge at the end, it's someone else, actually it's an ACS person who reported you as having a problem.
As far as the charge, the ACS is never included in the charge.
But that's what emerges at the end.
In the
When
decision,
it's all
that's
over,
correct.
you know that that's what's happened.
That's correct.
Why are you prejudiced by that?
Because this is a very opaque investigation, and what I mean by that is we have very little information. So we prepared based upon the allegation. And Whitbread makes it very clear that that is an important element.
In fact, the administrative law judge who heard the case found in your favor and dismissed the charge because of this deficiency in what you had been told about what the charges were.
That's correct. And also, it permeated throughout the investigation. There are instances of, in particular, the most important one is the interview and the testimony of Sherry Romano from OMH. And she makes it very clear that her problem with what happened here was that this was retaliatory against the service recipient for her allegations, and that therefore it was the retaliation against the service recipient that overcame any kind of therapeutic needs that she might have. And that was totally it was the charge, and it was the crux of her testimony. And she was the only fact opinion witness that was involved in the investigation that testified. Her testimony was particularly important because a lot of it came after the initial report had been submitted by the investigator to the Justice Center. Legal counsel said, please go back to Sherry Romano and Mary LaPointe and give us more information about the harm that was done to the child, to the service recipient. So they relied on her testimony and her interview in prosecuting the case.
Sir, I'm sorry. At the end of the day, it's not disputed that the center did not have an appropriate discharge plan for the service recipient after there was an emergent situation, alleged emergent situation with the battery being swallowed. That's undisputed, correct?
Because of the emergency situation, yes.
That part is undisputed, but at some point when they determined that there was no battery in the child, and then you have to plan for where is the child going to go and not necessarily have to stay in CPAP, there was no plan to try and take the child back or with all the bells and whistles that the state protocols require and that this center would otherwise have adhered to, correct?
That's correct. But there's a fundamental reason as to why that occurred. The emergency aspect of this, no one planned the confluence of her being taken to a hospital because of allegedly swallowing a battery. And best information we had at ICON was that she was then admitted into CPAP, which she was.
Oh, wait a minute. But the fact that there was an emergency resulting in her going to the hospital didn't relieve you of your obligation to create a discharge plan, correct?
Well,
And
it's not a
You could
question.
have worked on a discharge plan while she was in the hospital. You could have, and there was still no discharge plan at the time the hospital was left with making the decision of where to send her next. You didn't make that decision, correct? Your client.
When
Did
it
your
was
client make the decision about where she would go from the hospital?
no, nor was it our client nor was our client asked where she should go from.
Wasn't
where
it your
to the
client's duty to do that regardless of whether you were asked? You had, as the last facility housing her, wasn't it your obligation to create a discharge plan?
Well, I think we may be talking about two different things. The discharge plan is more extensive as to where she might go.
Right, which you
Problem
never
was
did,
that she
right?
was.
You never did a discharge plan, right?
The discharge.
Is it correct that you never made a
That's
discharge?
correct, because the idea was that ACS was in charge of finding another place for her to be,
And
because it
who
was
decided
ACS that was the
ACS
custodian.
in charge at that point?
I'm sorry?
And ACS relieved you, told you that you didn't have any obligation to do the
Actually, there
discharge
never
plan?
was an inquiry from ACS as to.
Wasn't ACS going to remove the service recipient on an emergency basis on August 7th until there was that meeting?
That's a very important point. They made it very clear to ICORN on that day, and in fact also to the service recipient, that they were removing her from ICORN that day, and they were
The
trying
only
to
reason they
find a
didn't
place for her.
remove her was because Ms. Brown arrived, and Ms. Brown had had a relationship with the service recipient, and she seemed to have been able to ameliorate the problem.
Which is an important point to show that ICORN was not.
Otherwise, the service recipient would have been out on August 7th. Wouldn't she have taken out by ACS?
Without any opportunity for a discharge plan to be produced by ICORN. But it's very important to note that ICORN gave all the information they had whenever requested, and there's a litany of it in the evidence as to their cooperation with ACS and with Children's Village, despite the claims based upon misinformation by Ms. Romano, who had no information concerning this.
Also, isn't what happens on August 7th that, well, it happens, I don't know if it's August 8th or August 9th, that when there's this complaint called in by ACS against Ms. Brown, Dr. Powell comes to the conclusion that they can no longer treat her, that it's just impossible for them to continue to have a relationship with them because Ms. Brown, who's the program director and who's had this relationship with the service recipient, is now in a position where a charge has been brought against her, not just by the service recipient, but by ACS. And isn't it a much more serious problem for the petitioners when it's ACS making a complaint against someone who's in a leadership role at the petitioner's facility?
You're precisely correct, Judge. That was exactly what the problem was here. That's what made this so unique. It's important to note that despite the complaints by the
Ms.
service...
Brown had been at that facility for 27 years, hadn't she?
Yes, and she was well respected, and in fact, ACS personnel that were there, but for the anonymous complaint by one of them, were complimentary to her, that she saved the day in being able to keep the service
Your
recipient.
time is up, so
person
just
who
I
filed
couldn't
the
check it out from the record, but the petitioners are now out of this. They've closed the facility, is that correct?
Yes, for unrelated reasons.
Unrelated reason?
Completely unrelated.
Thank you,
That's
Counselor.
correct. Thank you, Judge.
Good morning, Your Honors. Andrea Trento from the Office of the Attorney General here
Could
for
you
the...
address the due process issue first?
Sure, Your Honor. The charges stated in the charge against these petitioners fairly encompasses the charge that the respondents improperly discharged this troubled teen to an appropriate setting in response to the teen reporting
What
reportable
specifically
incident.
did the charge say? The charge was 28 words, right?
The charge specifically says that the respondents improperly discharged the service recipient to an inappropriate setting in response to the service recipient reporting a reportable incident. And what happened at this
And
August...
based upon that charge, the administrative law judge doesn't sustain the charge because it's not a reportable incident from a service recipient, but it's in fact from ACS.
Your Honor, what happened is ACS was the reporting entity here with regard to all of the conduct reports.
But it's a complaint that comes in from ACS, right? It's a complaint from ACS that comes in against Ms. Brown, who is the program director of in this facility.
It's a complaint that comes in from the service recipient, Your Honor. What happened at the August 7th
Why doesn't
meeting?
that sort of discrepancy matter in terms of due process? I mean, there's not much information that the petitioners receive about why they've fallen under investigation, and there's a long investigation with a lot of witnesses. Ms. Brown herself is under investigation for 6 months, I believe, before she's cleared. Why doesn't it matter whether the complaint is coming from the service recipient or from ACS? Why doesn't it matter that the petitioners know this in the charge that's made against them?
Because the charge fairly encompasses the conduct that for which they were
Service
found liable.
recipient is equal to ACS?
The service recipient made a complaint to ACS representatives at this red flag meeting. She made allegations about things that were said to her by staff members of ICORN, and then in response to that, the ACS representatives
Someone
wanted to
9/11
call.
called that day.
The ACS representatives wanted to call 911. And what happened at the meeting is Ms. Brown said there's no need to call 911. And so as part of this nucleus of facts, in response
Because she's
to...
taking her out of the area in the facility with the people that she's having a problem with and putting her in a different place.
I'm not following your question, Your Honor.
It's not like an arbitrary decision by Ms. Brown. I mean, the reason Ms. Brown says there's no need to call 911 is because she's complaining about certain individuals at the facility. We're not going to let those people deal with her anymore.
Sure. Ms. Brown was able to convince ACS representatives that there was no need at the time to call 911. And the parties at this red flag meeting reached an agreeable resolution to the situation.
And then the next day, ACS calls in a complaint, right? Someone from
ACS did call in a complaint in response to the service recipient making the allegations.
Is a complaint being called in by the service recipient equal to a complaint being called in by ACS?
It's a complaint of a reportable incident, and these are mandated reporters under penalty of face misdemeanor criminal penalties for failing to make a report.
No question about it. But is whether a complaint comes from the service recipient or whether it comes from ACS, because I would imagine, and correct me if I'm wrong, that complaints must come from people situated such as the service recipient a lot more often than complaints being called in by ACS, where ACS says, we saw a problem there, which is what happened here.
I can't speak to the frequency with which these kinds of complaints are made, but these mandated reporters, the Justice Center, when it establishes this complaint process, it directs mandated reporters to, if you see something, say something. There is a bias toward calling in complaints when something that could be reasonably classified or the person reasonably believes is a reportable incident is required under criminal penalty to report
No question
that.
about it. But the question is, when you let the petitioners know that they're under investigation with a 28-word paragraph, does every word in that paragraph matter? And is it okay for you to say service recipient as opposed to ACS in that charge?
The charge needs to be reasonably specific to allow the party charged to prepare an adequate defense. In this case, at the hearing, the petitioners here, in their opening and their closing, said, we're going to show that the discharge of this individual was proper, was not in retaliation of any complaint made by the service recipient.
Is there any dispute about that, counsel, that the discharge here was retaliatory?
Yes, that's the charge. The discharge here was retaliatory.
But on the facts here, is there an argument to say that it wasn't retaliatory?
I don't believe so, Your Honor. Even if
Why
you
is that?
accept,
Why is that?
because the discharge was made here because of an allegation that was made against the Justice Center, even accepting the characterization of my
But isn't
colleague
the
here.
petitioners, and I think there's no expert testimony on this other than Dr. Powell, who's running this facility for many years and is obviously a licensed psychiatrist. He says there's no way that we could continue to treat this person after her complaint, if you will, about Ms. Brown, who's the program director.
Well, Your Honor, that's certainly what he's testified to, but there is actually no policy at ICORN requiring separation. They have 10 pages of a policy manual on the record, and there's nothing in there that says you need to separate the individual from the person against whom an allegation is made. This is a case-by-case analysis, and there's nothing in the record to suggest that any specific assessment based on the nature of the charges, based on the therapeutic need of this patient.
Is it that a complaint is made, or does it matter that it's the program director who is someone who has had a relationship with the service recipient and was the one who was really dealing with her difficulties?
Certainly the relationship between the teen and the subject of the charge is a factor to consider in the assessment of whether separation needs to be made. But even accepting that there was no therapeutic possibility for this individual to receive treatment at ICORN going forward, there was no justification for them to abruptly discharge, to engineer her admission to an emergency department and say, it's not our problem now.
Counsel, Mr. Fishbein argued essentially that the petitioner was absolved of its obligation to create a discharge plan because ACS took over that role, and therefore the petitioners had no further obligation to do a discharge plan. Is there any basis for that in the record?
There's no basis for that. In fact, the law requires them to coordinate with ACS, with the custodian of the child, and with the stakeholders, with the child herself, and with the child's parent in preparing a discharge plan.
And I didn't see anything in the record where ACS said to them, we're good, we don't need your help, we don't need to...
On the contrary, Your Honor, there were several emails after the service recipient was admitted to the emergency program at the hospital. There were several emails from OMH and ACS saying, hold on, before you make any decisions about discharge, let's talk about this. We still have obligations to this teen. And then another email asking for a follow-up meeting that had just been discussed at the red flag meeting because there were still elements of the treatment of this child with regard to her medication, with regard to her psychiatric care, with regard to her nutrition, that there weren't individuals at the red flag meeting there to address. We need to help this teen out.
So how did the breach of the discharge plan, how did it impact on this young woman's condition?
Well, this is obviously a very troubled child, and she is at this point at her most vulnerable. And so I think it was Executive Director Miranda cited the testimony of Ms. Romano in saying that this presented an unacceptable risk to the well-being of this child, in finding that ICORN's essential abandonment of this child at the emergency department of a hospital was unacceptable.
Thank you, counsel.
Thank you.
I'll only have 2 minutes, and I'll be very, very...
I'll give you an extra minute.
I'm sorry,
It's almost Thanksgiving. I'll give you an extra minute.
I'll take 3 then.
You got it.
On the 911 call issue, just so the facts are clear, it was Ms. Brown who explained to the ACS people there at that meeting that there's no need to call 911 because if you needed a psychiatric evaluation, ICORN was a psychiatric facility, a licensed psychiatric facility, and the evaluation could be done there, and in fact, it was done there.
But wasn't the issue that the so-called misconduct, let's accept for purposes of discussion that the service recipient accurately reported that staff members were encouraging her to commit suicide, and we know that we've had episodes of this in this country and where unfortunately people have been convinced to do that, and they've been criminally charged for doing that, and that is the basis for 911 arguably, perhaps to make an arrest. I mean, we don't know. What you're saying is really based on speculation.
No, it's not, because it's actually based upon the testimony of Ms. Brown, and because she was at that meeting, and that was the issue. In fact, that was one of the astonishing things that caused Michael Powell to write that email, because he was so angry at ACS. They didn't even understand the nature, this unit, this close-to-home unit, they didn't even understand the nature of ICORN as an RTF and that it was a psychiatric facility. And that was part of the anger because they were interrupting the therapy. It's critical that when these complaints on the 7th were made to Ms. Brown, she told them there's going to be a separation here because that is what we do. When there is a complaint against one of our staff members, we separate them because it protects the children and it protects the staff member. So ACS knew this was going to happen. This wasn't just out of thin air they decided to keep Ms. Brown separated. It was critical. Suppose they didn't separate her. Suppose that, in fact, she was returned to the facility and Ms. Brown was there, and there was a incident.
Return to the facility
In
after
other
the
words,
hospital is, excuse me.
From the
after
hospital, yes,
From the hospital?
that's correct.
But ICORN wasn't willing to take her back.
For good reason.
Your supposition is,
No, but that's my point. The point is that Michael Powell made a medical decision that it was safer and more therapeutic for her to remain at the hospital.
Was that put in a discharge plan, Counselor? I mean, it sounds like an after-the-fact justification at this point. Was there a discharge plan explaining all that and saying why she needed to be, that the hospital was the best place for her before she went off to another facility?
Well, there was a discharge plan
could you
that
show
was.
us where that conclusion
I'm sorry?
excuse me, could you show us where that conclusion by Mr. Powell is documented in the record in some way that would be appropriate medically?
Well, he testified to it under oath.
Dr. Powell testified
But there's
that
no
once
written-
that
he didn't-
complaint was
I'm
made
sorry.
against Ms. Brown, it was not possible for them to continue treating her. That the three people in charge of this, the petitioners, were not in a position to continue having responsibility for her treatment. But your time is up. What at the end justifies your having left the service recipient at Bronx Lebanon Hospital?
What justifies
What
it?
justifies it, yes.
She was at a secure facility, psychiatric facility. She was at a hospital. I can't imagine a safer place. Temporarily, we're not suggesting that she should have been there for a year. Temporarily, I can't imagine a safer place.
Wasn't
ICORN
that
was not
in a
as
place
safe.
where she was supposed to be only for a day or two?
I'm sorry?
Wasn't that a place where she was supposed to be there only for a day or two? Where she,
Was
the
it
unit
CPAP?
that she was, you're right, just CPAC, she was supposed to be there only for a day.
I mean, why
It
did she
wasn't
go
a
to the
place-
hospital?
It wasn't a place you leave someone for an extended period of time.
Oh, I'm
It was an
sorry.
emergency room application, right? So it was just actually not even a day or two. It's just you do an X-ray and you take her back.
But they didn't. The
They didn't.
hospital, no, the staff for ICORN stayed there until she was admitted to CPAP. The hospital took the X-rays, saw there was no battery. But then they admitted her into CPAP because they believed that she should be psychiatrically evaluated. It was at that point that the staff of ICORN left because she was staying. And we believed that she was there for days and that they were treating her. That was the impression that ICORN. There's only testimony that the hospital called ICORN to say she was being discharged, but they left a message. They couldn't reach her. It was the middle of the night. There is no evidence that ICORN knew that the hospital was ready to discharge her.
Counsel, I have a question. You talked earlier about, in response to my other question, about Mr. Powell's medical conclusion that the best place for her was the hospital, and that occurred in testimony. Was there any contemporaneous writing he did to confirm that stated that? Or was the first time that came out in testimony?
In the email, Your Honor, that was sent on August 11th, where he's explaining.
What's the record site, counsel?
Page 80, starts on 807, but the relevant portion is on page 809, where he explains, we are effectively powerless to intervene therapeutically with this youngster, and her continued stay at RTF can serve no further purpose.
Wait, this is not contemporaneous. This is long after the fact, right?
No, long
This
after,
is 2 days,
this is
2 days after.
August 11th.
Okay.
Yeah,
4
this
days
is contemporary.
Not contemporaneous with his reaching that conclusion that you claim he reached earlier, right?
I'm sorry.
There's no documentation as to his conclusion as to that was contemporaneous with his reaching that conclusion.
Dr. Powell.
Is that correct?
That's correct.
Thank you.
Okay,
That's
thanks.
4 days, that's 4 days after the email, after that meeting.
That's correct.
Thank you, Counselor. YH Lex Estates?
May it please the court, Dan Rottenstrike on behalf of the appellants, Renee Bartolacci, who's with us today, and Hermitage One LLC. On February 10th, 2022, YH Lex commenced a turnover proceeding on the Article 52 of the CPLR. 3 months later, without a trial and without much discovery, summary judgment was granted.
It was a special proceeding, correct?
It was a special proceeding
And
under
are you
Article.
entitled to unfettered discovery in a special proceeding?
Well, that's part of the issue here. From the procedural perspective, Your Honor, if someone's being sued and facing a $13 million potential liability.
Fair enough. But what discovery would you need from the judgment creditors? Because you folks are making the transfers. So it would appear to me that a lot of the information in terms of the whys and hows of the transfers was information within your control.
So the most important fact in a fraudulent conveyance claim, respectfully, from a transferee perspective, and that's what Ms. Bartolacci was over here, the transferee, is whether she ever had any knowledge that her husband owed money to YH Lex.
This is not an arm's length transfer. This is a husband and wife. Isn't that a little bit different in terms of the availability of information for her? Especially when the court, especially when the proceeding against her husband had been going on for a long time and the court recommended that they bring a separate action against her. So she knew this was coming. I don't understand why it is that you're describing her access to information as so limited in time.
Respectfully, YH Lex never even alleged that Ms. Bartolacci knew about.
So intent. You're arguing intent, as I understand it. Right?
So there's two
What are
elements.
You're arguing intent, essentially.
Put aside the procedural issue.
So, well, but let's just deal with the statute.
Okay.
73A. Is the wife's intent an issue for such a claim?
It has to be, otherwise you're imposing strict liability in the amount of
But
$13 million.
Wouldn't we be rewriting the statute if we were to look at the wife's intent as to what she knew about the husband?
No, if you look at the plain text of the statute, it says nothing about holding a transferee liable for money. The fraudulent conveyance statutes, as well as Article 52, is intended to get back property.
But this plain language of this statute speaks of actual intent referring to the debtor, not to the debtor's wife.
And that's to void the conveyance. There's not a word in that statute that says a transferee could then be held liable for $13 million. If this was just an action
If
to
you're
get...
vacating the transfer, that's what would happen.
So if the property was still there in the typical...
So the property was dissipated, and you're saying that because the properties have been dissipated, there can't be a judgment against the wife?
No, so now we have a traditional fraud claim that this was a conspiracy to defraud YH Lex. Respectfully, you have to establish some mens rea on behalf of Ms. Bartolacci. You can't impose strict liability on a transferee. I was saying before, YH Lex...
So what does 274A mean when it says that a transfer made or an obligation incurred is voidable? It doesn't speak about looking at the intent or what the recipient knew. It speaks about the debtor.
And the case law would typically explain that fraudulent conveyance statutes were enacted to help get back property in the first instance if it was conveyed. When it's gone, I acknowledge that there can be a monetary damage here, but respectfully, if you're going to hold a transferee liable for money because the property no longer exists, there has to be some...
What happened to the money? What did the wife do with the money?
Respectfully, Judge, according to YH Lex, not to me, according to YH Lex, Mr. Neer, the husband, took the money back, at least $5 million, and they make no attempt whatsoever to account for any of the other money. And the law is clear. You cannot impose, so put aside the intent issue, now I'm on to damages. You can't impose joint and several liability. That's the law in New York.
So in other words, so let me understand. So the husband can make, husband-wife, close relationship, can make a transfer without consideration. The asset is dissipated, and there can be no judgment entered against the wife? Is that the law? Is there any case that supports that position?
Respectfully, Judge, the husband and wife have a close relationship, and 8 times out of 10, I'll agree with you, that smells. It smells. They collude, and there's a lot of cases where the husbands and wives colluded. That's not absolute.
Finish up,
It can't
counsel.
be absolute, because what you also have when you have a close husband and wife relationship, you have many situations that this court has seen where one person will exploit that relationship, use the wife as a patsy in a scheme. And I just want to refer, Your Honor, if I can, please, to ask you if there's one thing I could ask.
Oh, so in other words, the wife may have a claim against the husband.
Yeah, but also it goes to.
But counsel, I'd like you to hold your fire until you reply. We were at the red light. Thank you.
Thank you, Your Honor.
Thank you, Your Honors. So this case involves a $40 million approximate property in the Hamptons that the husband, Mr. Meyer, owned through LLCs. They're married.
Can you respond to the arguments that wife's intent is an issue here and that there cannot be a judgment against the wife without essentially further proceedings to establish fraud?
As he pointed out, it's totally inconsistent with the statute, and there's no case law whatsoever that supports the
She's
argument.
clearly not a bona fide purchaser for value.
She's not. In fact, below,
Didn't they argue below that she gave fair value?
they did. She now has new counsel because they're going through a divorce. She's represented by her divorce counsel now, so they want to separate themselves. Below, there was the good faith and fair consideration defense raised. Astonishingly, she now claims through her new counsel that she lied about the fair consideration before. There were affidavits filed that said, I contributed millions to the property.
Well,
In her appeal
she
brief, says
claimed
that
she
that wasn't
contributed
true.
5 million.
Excuse me?
She claimed she contributed 5 million.
That was that
Claim.
was argued below. But
And this whole conduit and intent argument is raised now on appeal, correct? For the first time.
For the first time, some of it for the first time in the reply brief. Part of what's troubling about that, Your Honor, is after the appeal was scheduled, just in the last few days, Ms. Bartolacci has filed an order to show cause in the IAS court, seeking to raise the same arguments that are being raised here. Totally meritless arguments, completely divorced from the statute, and there's a hearing on that order to show cause on January 5th. This is an attempt to get ahead of the appeal that's been briefed for the last year and try to pull victory from the jaws of defeat. So it's important that you act promptly because your decision is going to moot that motion below. So intent is not required for the transferee. That's under the statute. That was true before the uniform statutes enactment as well.
What about the issue your adversary raised, that it's essentially unfair because there hasn't been more discovery?
That argument is not presented in any of the appeal briefs. There were lots of proceedings previously. There was actually, I think, a prior motion practice regarding the procedural issue that there wasn't enough discovery. That's not part of this appeal. That argument's been abandoned. It's not part of this appeal. There is no issue raised in terms of the substantive arguments they're making about they're raising a number of defenses that are just not available under this statutory scheme. So any discovery would be futile because there's only one defense available. It'd be good faith and consideration. They admit in their papers there was no fair consideration and that she lied about it. She says, oh, well, I was coerced by my previous counsel and by my own lawyers to lie before. Give me another shot. It's an astonishing position, Your Honor. None of the arguments raised in this appeal have any basis in the statute or any case law. It is entirely invented. If there are no further questions, I'll turn it over.
Thank you, counsel.
Your Honor, on November 9th, we filed an order to show cause before Justice Cohen at his invitation. We previously filed in July of 2023 in order to show cause.
Whatever happens below happens below. Just focus on the arguments.
It is to vacate the judgment that you're considering on different, it's in the interest
It's not before us. It's let's just deal with the issues.
Okay, I will respectfully ask you to take judicial notice of that filing, Judge. In the interest of justice, we have a lady here whose lawyer conspired with her husband. Justice Cohen found that already.
Limited to the record in front of us, counsel. Would you please stick to the record in front of us?
So with respect to liability, Judge, you cannot impose strict liability on a transferee. We don't have strict liability, but that's what they're arguing. They're saying
But
that
what provision of the debtor and creditor law supports your argument?
no provision of the debtor and creditor law says that you're allowed to get a money judgment against a transferee. It just says
But
that
if the
it's
money is
void.
gone, it's been dissipated, what other remedy would there be?
So now-
More litigation so that there'll be a judgment down the road?
No, now we have to figure out why is the money gone. There has to be some obligation to show, number one, that she spent the money. If a husband puts money in a joint account for 5
But
minutes...
isn't that a dispute between the husband and the wife as part of their divorce proceeding now? Why is it an issue with the judgment creditor?
The judgment creditor, first of all, he did not have a judgment. They did not have a judgment. It was an unsecured loan. It was a personal guaranteed that was put on after it was already in default for no consideration, wiped out the family's entire life's savings. If you credit what YH Lex says, once that house was sold, there was no more money for this family, all done without the wife's knowledge and consent. And I understand that he gave a personal guarantee, and as between the husband and YH Lex, they could go after it. But if now you have a transferee, and the record is clear, she knew nothing about the debt, she knew nothing about the attempts to collect the debt, and their allegations are that the husband spent the money. Why are we imposing a $13.9 million liability on a housewife and mother of 3 that was used as a pawn in a fraudulent scheme? That cannot be the law here. It cannot. I'm sorry.
It's okay. Thank you, Counselor.
Happy Thanksgiving
Happy
to everyone.
Thanksgiving.
Thank you.
People versus Sproul?
Good morning, Your Honors. May it please the Court. My name is Elizabeth Vasily, and I represent appellant Mr. Tyrone Sproul. Due to the wide array of mitigating factors and the principles of co-defendant proportionality, Mr. Sproul's sentence should be reduced to 5 years. Mr. Sproul, at age 25, was a law-abiding citizen. He'd never been arrested his whole life. He worked a good job in construction, and he'd lost that.
No, I understand that, but few weeks after the first arrest, there was another incident. So how do we deal with that issue?
That's correct, Your Honor. Even with the second incident, the mitigating factors still support a sentence reduction. And Your Honor, the fact that it was 3 weeks later show that this is still part of the same breakdown, the same substance addiction that really spiraled out of control in the pandemic, like we saw with all substance issues in the pandemic. And this isn't just Mr. Sproul waking up one day and deciding to rob someone. There's a clear cause here and a clear reason that this happened, and that is a mitigating factor for both of the offenses, the other one which he was separately sentenced for.
But when you raise the proportionality to his co-defendant, how do you take into account that the defendant himself it was who pushed the cashier and stated, "I'll shoot you"? His co-defendant didn't do anything like that, did he?
Your Honor, his co-defendant brandished the fake weapon. So our position is that that
actually
conduct...
threaten the cashier verbally or push the cashier as the defendant did, right?
That's correct, Your Honor, and we don't dispute the seriousness of Mr. Sproul's conduct. We believe that warrants 5 years, but nobody got injured in this case, and a push is not a kick, it's not a punch. A fake gun had no capability of actually hurting anybody.
How about the threat, as my colleague referred to? I mean, that if I were the recipient of that threat, I'd be a little concerned.
Absolutely, Your Honor. It warrants a 5-year sentence, not a 6.5-year sentence.
So you start with the fact that he has this perfect record before this, but you're asking us for a discretionary sentence reduction, but this case doesn't come before us with him having a perfect record because, as Justice Singh pointed out, he's got the other case. And these are cases which really should have resulted in consecutive sentences. So he was given a considerable break when, in effect, the sentence that he received here really is like a year and a half, because the times are running concurrently, and statutorily is that even authorized with the way these crimes line up. So he's, in terms of the other sentence, the other robbery, this added only a year and a half to what he had received.
Your Honor, he was still sentenced to 2 separate convictions. His predicate felony status reflects that. And courts have often run concurrent time.
It's concurrent time.
Yes, Your Honor, but
And
courts
if it was done consecutively, how much time would he have faced? Close to 10 years?
That's correct, Your Honor. But for someone's very first
So
involvement,
proportionality, 10 years, if it had been consecutive versus roughly a year and a half. How do you respond to that?
Your Honor, the wide array of mitigating factors here still support 5 years. And courts often do run concurrent time of the same time for offenses that seem logically grouped together. And here, this was part of the same breakdown. And Your Honor,
Also,
before...
a lot of your brief makes the point that he really was working before, and he's laid off because of COVID. I mean, if he had a job and he's laid off because of COVID, I mean, there were a lot of benefits that were paid to people who lost their jobs because of COVID. I mean, there's no record about any of this. I mean, how this comes about, I mean.
Your Honor, substance abuse makes people into people that they aren't.
We're
And this
talking
was a
about the
true
job.
aberration of
We're talking
character.
about the job. You say he had a job before, and he finds himself in this situation because he lost his job because of COVID. So,
Your Honor, it's hard to separate out when someone's struggling from an addiction for them to think clear enough to go seek out the benefits. Losing your job in a pandemic, struggling from substance abuse. This court has time and time again considered addiction in reducing sentences, and I'll reserve the rest for.
Thank you.
May it please the court, Noah J. Sexton for the people. Based on your honors.
was the imposition of concurrent sentences here, in terms of how this played out, his being out on bail, was that even really a permissible sentence? That it not be consecutive?
It was, and it was part of the negotiated deal. We mainly wanted to, having spoken to the trial ADA who handled it, we wanted it to be done, spare the victim, in this case, the re-traumatization of having to testify at trial. I'd like to speak briefly to the so-called myriad of mitigating factors. There's really not a myriad of mitigating factors here. We have his biggest claim is that, oh, it was the pandemic, I was struggling, I lost my job. There were 9 million people languishing in this city when this happened because of COVID. There were millions of people across the country who didn't have jobs. There were business owners who were struggling, just like the business owners that defendant decided to victimize in not a breakdown as it was put down, but more like a burgeoning crime spree that got cut off because he was caught. On top of all of this, there was a perfectly valid appeal waiver in this case. The colloquy was more than sufficient. There's really no need for this court to entertain any of defendant's claims.
What about the fact, isn't the appeal waiver executed at the time of sentence and not before the plea? The written waiver.
That's typically best practice, but it's not dispositive of the validity of the waiver. Actually, back October 26, 2023, in People v. Matthew Nunez, that was an issue that was raised, and this court held, actually quite simply, that that is not dispositive of the issue of the validity of a waiver.
In other words, the fact that you signed the waiver, that the written waiver is signed at the time of sentence does not invalidate the waiver.
It does not. Obviously, it's best practice, and the people would not contest that, but it does not invalidate the waiver as a whole, so long as the totality of the circumstances indicates the defendant knew what was going on. Unless you have any further questions, I'll rest on the papers.
Thank you, counsel.
Thank you.
Counsel, I have a question. In your argument, you kept referring to defendant's breakdown. I didn't remember that word from your briefs, and so I just did a quick search of them and couldn't find it. And I couldn't find it in the record. Is there somewhere that the concept of a breakdown is actually supported in the record?
No, Your Honor, it's just considering all of the factors that he
see.
lost his job, he's struggling from substance abuse, mixing Percocet.
But there's no actual documentation that he suffered what anybody would call a breakdown, that a medical term of a breakdown.
No, Your Honor, no. It's just the confluence of factors. The appeal waiver was invalid. The court misspoke at the time of the colloquy and said that separate and apart from the plea instead of trial, it needed to explain at the trial that this was separate and apart from giving up his trial rights. I just want to go back to most people on their first arrest get a probation or substance abuse treatment program or, a less significant sentence. And here, on his first arrest, to get this amount of time was excessive. And
But I hate to harp on this, but do most people go out and within a few weeks then commit another crime?
no, Your Honor, but people struggling with addiction do. And this court in People v. Alfonso is precisely akin to this. 3 of Your Honors were on that panel. You reduced a 7-year sentence for robbery in the first degree to 5 years because of an addiction. It was a robbery where someone swung a stick at a woman, robbed her, had only 1 misdemeanor before, Your Honors considered, that limited criminal conviction. And in that case, he failed to appear and committed 2 burglaries after that. But Your Honors still understood the importance of addiction, as we know through society now recognizes how through the opioid crisis and how people have been struggling from substance abuse result in crime and are acting out of their character. This was a true aberration of character for Mr. Spruill, never before arrested. I know these 2 offenses happened 3 weeks apart, but still, 5 years is amply sufficient, and 2 more in a year and a half won't do any additional help for him. He needs a treatment program. He doesn't need additional incarceration. A year and a half of additional jail time is not going to cure the root cause, which was the substance abuse. A treatment program is. It's better he's released now, closer to his job contacts, with his family to support his children, as opposed to just kept in for a year and a half more. Thank you very much.
Thank you. Diamond versus T.F. Cornerstone. Okay, Unity first.
Yes. May it please the court, I'm Paul Tarr.
Get ready. Take. Want to make sure we have the right person there.
It's me, Unity, also known as Paul Tarr of Lester Schwab, Katz and Dwyer. Good morning and happy holidays, Your Honors. May I begin?
Absolutely.
As a threshold matter, there is the issue of preservation, and I feel I should say at the outset, I did not draft the underlying cross motion. This case came to me after they were drafted. This court has discretion not only to consider the arguments that I've introduced for the first time on appeal, but should do so because they are dispositive. If this court holds to a hard line on preservation, you probably will not hear very much from me. But I assume if you let me go forward, you are willing to consider the merits. I will go one step further and say
So
you
you
should...
acknowledge that you didn't raise the issues about the applicability of Espinal? You didn't raise the argument about Espinal in the trial court?
They should not. They should have been in our papers.
Counsel,
They were not.
did you? That's what
They
I
were
was
not in our papers, and that is
asking.
why
I'm
I
sure if you
opened
had
as
done
I
them,
did.
they would have been, but they weren't there, right?
They were not there. And so
And it's your
I-
position that it's a legal issue and can be raised on appeal?
I'm sorry, Your Honor. I'm having
Is it your position that the issues you're raising are legal and can be considered on appeal?
Yes,
Okay,
they
so
are.
why don't you make your arguments? Don't know where we're going with it, but make your arguments.
Okay, very simply, there are 2 main issues that the motion court had. One, that we didn't properly consider the testimony of Mr. Fariso, who spoke of our, Unity's, fire safety director, Juan Torres. I break down what Mr. Fariso had to say about Mr. Torres in this motion. None of it goes to liability. My client is a fire safety contractor and coordinator. What they do, and that's spelled out in the...
So did your client launch the instrument of harm in this case?
No, it did
And
not...
why is that? Why is that?
Okay, it did not because the instrument of harm here is alleged to be ultimately, one, to some degree, dim lighting, My client is not responsible for repairing or changing light bulbs in the subject hallway.
Let's
And
assume for
ABM's
argument that there's some responsibility with respect to inspections for lighting. Is that in itself sufficient?
It is not sufficient, Your Honor, here because the instrument of harm is a tiny, minuscule, I would say de minimis chip in a single step. My client's obligation is to check for safety issues in the nature of loose handrails and obstruction to stairwells and exit. There is no fair reading of Unity's service agreement that would put the defect at issue within its bailiwick,
If a
within
chip
its
were-
portfolio of responsibility.
But if a stair were chipped to the level that it would cause somebody fleeing from a fire to slip down the stairs, wouldn't that be something that your employees would have an obligation to report as part of their inspection?
That, yes, Your Honor, but that is a big if.
Well, I
And-
understand that, but
Well, yeah,
that's
under the,
part of
under,
what the plaintiff
under those
contends.
facts, except in here, I would like to go, just take one step beyond my preservation argument. This power has, this court has,
Does a failure to report under Espinal make an independent contractor, someone who doesn't have a relationship with the plaintiff? Does it make that entity liable for it? Under
Not-
Espinal?
it can, but not under circumstances where you're talking about a de minimis defect that has no relation to the services my client is obliged to provide.
How would failure to report a chip on the stair constitute launching a force of harm? How would a failure to report constitute launching a failure?
Justice, it could be if that, if the condition that was not properly reported constituted a blockage or some obstruction of safe exits from the stairwells, because that is what my client did as a fire safety coordinator. But a tiny chip on a stair, that's a different situation. And under those facts, no. The first.
Well, contractually, what did your client agree to do contractually? Did you displace, for example, the owners, the management companies?
Not even close. If you're referring to the third Espinal exception, I submit it is not even remotely.
The plaintiff didn't even know who Unity was before this occurrence.
Never heard of us, didn't know what we do, didn't know such a service was provided.
At the most, someone once gave him a key in the lobby to some
Yes,
door.
we had a presence in the lobby as well. That's what we did. We are so remote from the nature of the obligation.
You say in the lobby as well. Actually, 1A of your contract, if you've looked at it, says Unity will provide licensed, unarmed, and uniformed fire safety and security personnel for the building lobby.
Your Honor, you are speaking directly to why my client is so peripheral to the issues underlying the alleged negligence.
Thank you, counsel. Thank you. We heard your arguments. Please proceed.
Good morning, Your Honors. Catherine Papandrew, Pecknick, Petkin, Schaefer, for the plaintiff, respondent, appellant, Mr. Diamond. With regard to counsel's arguments as to Espinal and the fire services contract that Unity undertook in the premises where Mr. Diamond fell, he neglected to mention that there was testimony from another witness, Ms. Archibald, who testified that Unity was responsible for inspecting staircases in the premises for all defects. And didn't
Is that a contractual obligation that you're referencing, or is that just what this witness believed was the obligation of Unity?
Well, it's interesting because the agreement doesn't specifically state, the service agreement between Unity and TF Cornerstone, the property owner, doesn't specifically state that they're supposed to be inspecting for fire safety issues only. So when Ms. Archibald was questioned as to what their responsibilities were contractually, she testified that they inspected for all defects in the stairways. And I believe, as Your Honor mentioned earlier, a chip in a staircase could pose.
I have, the contract is at page 1421 of the record, right? Exhibit O to the Solitsky affirmation. What in that contract shows that or supports that?
I don't think there's anything specifically in there that supports that. It's what's not in there that supports that, because
it's
it
not,
doesn't.
the only specific thing in there is providing licensed, unarmed, and uniformed fire safety and security personnel for the building lobby. It's the only thing that's in there, isn't it?
And that's the point, exactly.
But if it's not in the contract, aren't we just creating an extra contractual condition that doesn't appear? Aren't we bound by the terms of the contract the way it's written?
We are bound by the terms of the contract, but the contract doesn't specify what their responsibilities were in terms of providing fire safety and security personnel in the building. There's nothing that delineates that, and in support of their summary judgment motion, they didn't supplement that testimony with an affidavit of someone who could speak to the terms of the contract.
Thank
Do
you.
you, I-
Sorry,
a
go
very
ahead.
small
Go
question.
ahead.
Do you concede that the chip on the staircase was de minimis?
No, I don't, and thank you for bringing that up. I don't think it was a de minimis chip at all. I think it was a significant chip that caused Mr. Diamond to take a rather serious fall and sustain very serious injuries.
Thank you.
Thank you.
Daniel O'Connell for ABM. I just have one brief point in addition to what plaintiff said, and that goes to the issue of the third Espinal exception. Under that exception there, where you have shared responsibilities, you cannot completely displace the owner's duty for, in this case, inspection. So that if Clear was responsible for changing light bulbs or ensuring that the lighting was correct, there was also a responsibility on the part of Unity to check for fire safety. And I agree with one of the prior justices' statement, and that is indeed our position, that you inhibit fire safety if people cannot go up and down the stairs safely, and the chip is not safe, and nor would be.
But is that sufficient under Espinal if they did nothing to create the chip?
It's sufficient for one of the exceptions.
It sounds like what you're saying is, well, that's why the owner and the managing agent are responsible. But how does some outside contractor who comes in to do fire safety, or you might argue if you're ABM who comes in to wash the floors, how does it make them responsible? They haven't supplanted the owner who remains responsible for this, or the managing agent who remains responsible for it. They haven't supplanted the owner. They haven't done anything to launch a force of harm.
So maybe I should preface this. I spoke specifically to the third Espinal exception. If your honors do not believe that the first exception is applicable under these circumstances, because mere negligence, assuming you have a duty, the mere non-performance of a duty is not what gets you on the hook for Espinal. In that regard, ABM is in line with Unity. There was nothing that was done, no affirmative act or conduct, just as in Unity's case, that would put ABM on the hook. Now, I don't.
Well, we're not arguing your motion just now.
We'll get to ABM.
Have a seat. Thank you. Counsel.
Your Honors, very briefly, there are photos of the alleged defect in the record. Look at those photos. I urge you, if you can see the defect, you could.
On page 1465, it's pretty clear and it looks quite large.
I leave it. I have to leave it to the
looked at
court's
it again
discretion as to
because I
whether
was-
it's significant or de minimis. As to the third Espinal exception, I just must remind the court of the PALCA standard. We have a fairly clear, limited contractual undertaking. There is no way they could be complete displacement under the facts of this
Plaintiff
case.
argues that it's not in the contract. The contract's silent about that, so therefore it's something that should be considered. How do you
Correct, and
respond?
I think plaintiff would have this court take a improperly expansive view of what the contract could encompass. This court didn't seem inclined to take it. It should not. And finally, this court has discretion to consider things they are the record that are of record. There is a pending re-argument, and I say this only if there's any doubt as to the value of the witness's deposition testimony. There is a pending re-argument motion.
Counsel, we're just focusing on the
I
record.
mean, what the contract says about what the purpose of whereas owner and Unity desire to enter into this agreement covering certain fire safety and security personnel services described below.
Your Honor, I
The
think that
purpose is fire safety and security personnel.
I couldn't agree more, Your Honors. Thank you very much.
Thank you. Okay, now ABM. can make your affirmative arguments, counsel.
So getting back into this discussion where I left off, I would say that in this case, it is difficult to find a duty in the first instance on the part of ABM. I don't think anybody would
But
disagree.
doesn't ABM have a different problem? You're not quite in the same boat as Unity, because I believe the complaint says that you did things in doing your janitorial services that you affirmatively damaged the steps. And I mean, the claim is, I'm not going to tell you, it sounds like the most likely, that it seems like this great claim, but the claim is that the chemicals you used to wash the stairs enhanced the deterioration hastened the deterioration of the stairs and caused the chip. And you didn't refute that by coming back and saying, oh, we only used soap and water, or we used standard chemicals which do not have this damage. So doesn't that leave ABM not having made out its prima facie case on the Espinal factor that you launched a force of harm? The plaintiff has put that into the case, and you haven't successfully refuted it in seeking summary judgment.
So our argument, and I believe it is the correct argument, is that the only testimony, I mean, the factual record is the only thing that Your Honors could go on appeal, as the trial court should have. The only so-called evidence of these mysterious substances that allegedly built up.
But you had the burden to refute it.
We refuted it in our papers, and it was not discussed in the opinion. So to the extent that the only person in the entire case
How did
was
you refute
plaintiffs,
that, Counselor? How did you refute it?
our briefs discussed at length, and as did our appellate briefs, that the court should have and should in this instance disregard.
Put in an
But was there
affidavit.
anything factual to refute it by an expert or anyone or
That's what I'm
somebody
discussing.
on the?
The only thing in the case person to have discussed it was plaintiff's expert.
Right, and did you refute that in any way, either by any of your employees concerning what mild cleaning materials you used, or by an expert or anybody else?
We said
Apart
that no
from
one other than the expert, who did not even inspect it, said that there were materials. There's no
You
underlying
had the burden
factual-
to refute it. To make out your prima facie case, you had a burden of refuting that. You had to put in some affirmative evidence showing that this is not correct.
But it's not in the factual record. So
But
what
the allegation that you caused the deterioration of the stairs is there. That's one
speculation on the part
theories-
of the expert
that's-
and no
but that's-
more.
But that's part of the plaintiff's theory of the case, and you're coming and saying, give us summary judgment. So didn't you have to affirmatively refute that claim by the plaintiff in order to make out your prima facie case?
If you're saying that we had a duty to affirm the speculation of the expert that wasn't in the record, I suppose that's the case. Is my time up, or?
You got, well, about 50 seconds.
Okay, so I would just like to say to the extent that the trial court found that we did nothing other than say, oh, we didn't launch a harm, oh, we didn't create the allegedly dangerous condition. We in fact did. Our affiant, the person who submitted the affidavit, did make a blanket statement that they did not create the condition, but that
But isn't that a conclusory statement? I mean, all it required was we use vinegar and water, soap and water, we use, normal solvents that will not create this, whether it's through an expert or through an affidavit. Wasn't that part of your burden based on what the plaintiff is saying?
Well, the evidence that we did submit was that we were not there on Sundays. We only swept and only had a
The claim, Counselor, the claim is that the solvents you use somehow exacerbated the steps to create that condition. So it's a cause and create, not what you're saying, right?
It is their theory of the case that there were allegedly substances that were not identified that were caused to build up, according to the expert.
Thank you,
all there is.
Counselor. Thank you.
Very briefly, Your Honors, with regard to ABM's contractual responsibilities, I don't believe that they did establish their prima facie entitlement to summary judgment. There is the expert affidavit of Mr. Heller in the record, which indicates that the cleaning products may have caused a deterioration of the step. In the affidavit that was submitted by ABM, there is nothing in there with regard to the types of cleaning products that they used or the types of cleaning equipment that they used to clean those steps between the 60th and the 61st floor where the defect was, where Mr. Diamond fell. So I don't believe that they met their burden upon summary judgment.
Thank you.
Your Honors, very briefly, I submit the motion court has made this very easy for all of us. Had ABM site supervisor, Mr. Kaprick, properly indicated in his affidavit that ABM did or did not perform the work it was obliged to perform or not perform, had ABM submitted an affidavit that met its burden, ABM may not be sitting here as part of this appeal. That's all, Your Honors.
Okay, now we go to plaintiff's appeal.
Thank you, Your Honors. Plaintiff's appeal is with respect to the Labor Law 241-6 claim.
But there was no construction at the building. Wasn't your client working for Otis doing a routine maintenance job as required by their contract?
He was an employee of Otis Elevator, but he was not performing routine maintenance at the time that his accident occurred. He was in the building to perform repairs to the elevator. He testified to what those repairs were.
Is there any evidence that those repairs were part of an ongoing construction project?
There was testimony by Mr. Diamond as well as Mr. Fariso, who was the chief engineer for TF Cornerstone at that time, that there was ongoing construction projects in the building and that freight elevator was used in connection with those construction projects that were ongoing in the building on the date that Mr. Diamond fell. There's been a lot of, in the motion papers, there's been a lot of arguments with regard to the fact that Mr. Diamond's supervisor, Mr. Rowley, testified that the repairs Mr. Diamond performed were maintenance. However, what the...
But isn't that consistent with the contract here, that Otis was performing routine maintenance of elevators?
They had a maintenance contract, but within that maintenance contract, it also indicated that they performed repairs to the elevator, as well as, as well as monthly maintenance. And on this date, Mr. Diamond was in the building to repair gibs, which prevented the elevator doors from going off the tracks. He performed repairs on the hatch doors, which are the stationary doors on each floor that stay shut when the elevator is traveling up and down the shaft. These are clearly repairs. This is not maintenance work. And Mr. Diamond testified to that. Mr. Rowley testified that it was maintenance. However, Mr. Rowley only had approximately 6 months of hands-on elevator repair experience, whereas Mr. Diamond had been repairing elevators for 35 years. So even if the court doesn't see that as Mr. Diamond actually doing repairs, it does create a question of fact and credibility as to what those repairs were and who is properly characterizing them. With regard to the construction element, there was ongoing construction in the building. The trial court overlooked the testimony of...
But Otis, you concede, had nothing to do with the construction.
I'm sorry?
You concede that Otis had nothing to do with the construction.
Otis itself had nothing to do with construction, but the elevator was used by the contractors in the building to transport contracting materials and equipment to the various floors in the building in order to do those projects. Without the elevator, the construction doesn't happen. It's no different. I'm sorry.
Isn't the elevator required at all times? Don't you have to have that elevator properly working whether construction is happening in one part of the building or not? Doesn't that have to
I'm sorry, Your
be
Honor.
working properly?
This particular elevator was a freight elevator, which was used primarily for construction projects in the building and for deliveries that were made in the building. Without that elevator, those projects and those deliveries don't get made. The construction, although Otis didn't necessarily have anything specifically to do with the construction, the repairs that Mr. Diamond made to the elevator were incidental to and related to the construction that was going on in the building, thereby bringing him into the statutory protections. Construction site is a flexible concept. This court has ruled that in Karofsky. I believe it was in 2018, that it's not limited to the location where the actual construction is taking place, but it has to do with the circumstances of the
So
construction.
the worker doesn't, under your theory, the worker doesn't have to have any connection to the construction, correct? That's your theory, essentially?
I don't believe it's that he doesn't have connection to
What's his connection to the construction?
his connection to the construction is that he's repairing the freight elevator that's used for the
Pursuant to a contract with Otis for routine maintenance.
That's correct. However, I don't see it any different than an elevator on a traditional construction site, that if that elevator stopped working and a repair person was sent out there to repair it, I believe that that individual would come under the protections of 241.6. It's the same type of a situation. Simply because the elevator isn't located exactly in the middle of a construction site doesn't make it part of the construction and doesn't mean that the repairs aren't occurring in the context of construction. I think that's that concept of a flexible construction site.
Thank you, Counselor.
Thank you.
May it please the court, Jessica Smith for defendants, respondents, TF Cornerstone, and Carnegie Hall Tower. As we've already touched upon during plaintiff's argument here, there is no connection between the plaintiff or Otis and any ongoing construction.
So your adversary argues essentially that the freight elevator was being used for construction, hauling materials and supplies, and it was more than routine maintenance. There was actually the elevators weren't working properly, presumably, and that's what he was doing. Is that sufficient to bring him under the labor law?
No, at the outset, repair here is not covered under Section 241.6 unless it's in the context of construction. This was not in the context of construction because it was a maintenance contract. Now, even if we accepted plaintiff's proposition that somewhere at some point there were construction workers in the building who needed to use this elevator, that's still not enough. If we accepted that fact for the sake of argument, plaintiff's work would still be a completely separate phase of work. It would not be ongoing or contemporaneous with any ongoing construction work. His continued presence would not be necessary, but even it still would not be connected to any ongoing project. Plaintiff was not called to the site.
Counsel, let me ask you a question. If there was a major construction project going on in the building and plaintiff came to the building in order to do routine maintenance on the freight elevator, in order, partly because of the routine maintenance contract and also to facilitate the use of the elevator in the ongoing construction, would that make a difference?
No, it would still be routine maintenance. It's still not a sufficient connection. He wouldn't be employed in the construction context, and the reason why he was really at the site was more connected to the maintenance activity. And just briefly turning to this idea of whether he was in fact conducting a repair, here he was simply changing out component parts which he admitted would wear out over time. He had done this 1,000 times. This was strictly in connection with maintenance work of the type that he would do every day in his
He wasn't there because of any construction project.
Correct, and Raleigh, the supervisor, actually testified that this was considered an overtime maintenance assignment, which is why he was called in to perform this on a Sunday, so he would have sufficient time to perform this maintenance work. If you recall in the record, by plaintiff's own admission, he had actually been there previously on a Tuesday, and this was a pre-planned time that he was going to come back and install these replacement parts that were kept at the building in the permanent elevator, Otis's permanent elevator maintenance room. So this is all just simply they're part of an ongoing maintenance contract. There's even no actual indication of a specific construction project at the building at all. The comments in the testimony that plaintiff refers to is just that if the construction workers were there, they would need to use the freight elevator and nothing beyond that. So if there are no further questions, I'll rest on my briefs.
Thank you.
Thank you.
Good morning, Judges. Mike Winter for Clear Electric. The issue with my opposition to the plaintiff's brief is that, number one, our client was an electrical contractor
electrical vendor hired for the building. They are not an appropriate labor law defendant, so a 241-6 claim against them is inappropriate. They were not an owner of the building, they were not a general contractor, nor were they an agent.
And were you there in connection with a construction project?
No, they were not. No, they were hired by ABM, the building manager, as a lighting vendor to maintain the lighting in the building.
Thank you.
And if there are no questions, I'll rest.
Plaintiff? Unless, plaintiff's the only one who asked for more time. So plaintiff.
With respect to the arguments that TF Cornerstone made with regard to the construction in the building, the testimony was very clear by Mr. Friso that there was ongoing construction in the building. In their motion for summary judgment to dismiss the 241-6 labor law claim, they didn't submit any evidence to counter that testimony that there wasn't any construction going on in the building. There was no affidavit from anyone.
I don't think the issue, I'm sorry, I don't think the issue is whether there was construction or not. I think the focus is the plaintiff and what the plaintiff was doing pursuant to his employer's contract with the building. He was there to do routine maintenance on the elevator, that there may be construction in other parts of the building, maybe they're rehabbing apartments or whatever it is they're doing on the towers. On this record, was there evidence that your client was involved in a construction project as a subcontractor, so to speak, as we would see in many of these kinds of cases? The answer would be no, correct?
No, there's nothing that shows that he was involved in a construction project as a subcontractor. However, he was doing repairs on the elevator. This has been the source of much debate as to what constitutes a repair as opposed to maintenance.
What construction work was going on at the building at the time?
I'm sorry?
What construction work was going on at the building at the time?
We don't know what construction work was going on. We only have the testimony that there was construction work going on in the building at the time that this accident took place.
It could be anything. I mean, how tall is this building?
You know, I'm actually not sure how many stories the building is.
It's many stories
I
tall.
apologize.
It's many stories tall. I mean, what you're saying is if this elevator is, you know, on one side of the building and on the other side of the building on the 20th floor, someone is remodeling an office, that's construction work going on in the building, but it's got absolutely nothing to do with this elevator.
Respectfully, the elevator needed to be used to transport those construction materials and those construction workers and that construction equipment up to whatever floor it was where the work was being done.
It's just speculation.
I'm sorry?
If you can't tell us what construction there was, how can you tell us that this freight elevator had anything to do with this mythical construction project?
It's based on the testimony of the chief engineer for TF Cornerstone, who testified very specifically that there was ongoing construction in the building and that this freight elevator was used by those construction workers to transport materials and construction equipment up to the floors where the work was going on.
Thank you, Counsel.
Thank you.
Sorry. Is anyone left? I think they're done.
I think you're done. Sorry. I look up, I was about to call the next case. You're not staying for Thanksgiving, are you? Okay, People versus Javier. No, no. I'm sorry, go ahead.
Yes, good morning. May it please the court, Svetlana Kornfein for appellant Albert Javier. In 2019, this court reversed the judgment of resentence and remanded the case to restore to the original sentencing the concurrent consecutive sentencing structure for counts 24 and 25.
Is it your position that this required your appeal, you're arguing that requires a total do-over over the entire,
well, it's
as opposed to just correcting the Norris issue with respect to count 24 and count 25?
Yeah, yes. First of all, this was a resentencing under the Drug Law Reform Act, under the DLRA.
No, but my point is,
Right.
is it your view that he's entitled to a third bite of the apple, if you will, to have a total resentencing to consider mitigating factors, as opposed to simply addressing the Norris issue of count 24 and count 25 to be consistent with the earlier decision of this court.
He was not sentenced properly under the DLRA, and the judgment and the reversal of the judgment of resentence left him vacated his sentences.
Oh, so
He
your
had no
position,
sentences.
he's entitled to sort of essentially a plenary resentence.
He is,
But is that
because-
consistent with our case law?
Yes, it is, because it's consistent with the DLRA. In 2015, when this court first reversed to fix the Norris error, the court said in compliance with the procedures of the DLRA. Under the DLRA, the court was required in imposing sentence to make him an offer after a hearing in which he could present mitigation evidence. And then, if the court decided in its discretion that it would keep these sentences of the aggregate of 30 years, then Mr. Javier, under the DLRA, could appeal that offer. Or if the court made a favorable offer that lowered his aggregate sentence and Mr. Javier accepted it, that would be the end of the litigation. Or if the court just made the offer, Mr. Javier rejected it and opposed the sentence, then Mr. Javier could appeal the excessiveness of that.
I understand what you're saying, but don't our cases essentially hold that where there's a remand to correct an illegal sentence, as there was here, that does not entitle the defendant to a plenary resentence?
Yes, except that in 2019, this court reversed the judgment of resentence. He had no sentences, so new sentences had to be imposed. And because it's a DLRA resentencing, they had to be imposed in compliance with the DLRA, which requires a hearing at which he could present this mitigation evidence. It requires the court to have made him an offer. That was not done. And in addition, the court created a new Norris error, a new error in the, so it has to go back so that the court can fix that. When it goes back, the court then has to have a hearing, permit Mr. Javier to present this mitigation evidence, consider it, and then make Mr. Javier an office. That is the procedure under the DLRA. That was not done here. That's why the case should go back, not only to fix, again, finally, we hope, the Norris error, but to properly sentence.
Well, is that error something that we can fix?
No.
Why is that?
Twice before. First of all, it's under the DLRA, it has to go back. And twice before, this court, as a matter of law, has sent it back to fix. If it was something this court could have fixed, it would have done so. In 2019, the error, the original 24 and 25 was 25 is consecutive to 24, and then all the other 6 counts are concurrent to 24 and 25. In 2000, the Norris sentencing that was appealed from in 2019, that was 24 consecutive to 25. The court didn't, you could have just reversed it, but you didn't because it has to go back. You sent it back, and that's where we were in 2019. That trial judge now made 25 consecutive to 24. That was correct. But now he imposed 24 to run consecutively to all the other counts except count 25. That's incorrect. It's a new Norris error. So the case has to go back to fix that. And because it was a reversal and all the sentences were vacated, he has to have new sentences opposed, but under in compliance with the DLRA.
Thank you.
Good morning, Your Honors. May it please the Court. Jennifer Cavallas for the people.
So what about that? Was our 2019 decision where we remanded for resentencing, was it, in essence, I guess, a vacature of the entire sentence?
So could you repeat the last part?
Was it a vacature? Was our 2019 decision, in essence, a vacature of the entire sentence?
Absolutely not. In that case, the court made it clear that another resentencing on those counts is required, explicitly referring to 24 and 25. So the court here noted that there was an error, a Norris error with counts 24 and 25, and sent it back to remedy that error now newly created. That language cannot be interpreted to have vacated all of defendant's sentences. And if the court did mean to vacate all of defendant's sentences and send it back for a plenary resentencing, it would have used far different language, referring to counts 24 and 25 by name, make it clear that this court just wanted the trial court to remedy that error. It's unclear why the court here didn't just fix it itself, but it absolutely could, and it absolutely should now. In this case here, any error that is new here, and we're not conceding that there is an error, but if this court does perceive a new Norris error created, it should just remedy that itself, because it would be a waste of judicial resources to send this case back for a third time. And as Your Honor indicated, giving the defendant a third bite of the apple to continue to try to reduce his sentence.
Yeah, what about the argument that he didn't have a hearing and that a hearing was required?
Well, he did have a hearing. The DLRA only allows for one DLRA hearing, and that's exactly what defendant had in 2011. There was nothing defective about the DLRA proceeding. What was defective about that proceeding was that a Norris error was created. In that hearing, the defendant presented mitigation evidence and successfully got his sentence reduced by 10 years and the life sentence removed. Nothing about the DLRA was wrong there. It was only the Norris error, and that's what we're dealing with here is a Norris error. Nothing about the DLRA proceeding was defective. And as Your Honors have noted, this court has explicitly recognized over and over again that when a case is remanded to correct an illegality in a sentence, that proceeding is not meant to be a full plenary resentencing hearing. And Judge Klott did exactly that, just fixed the error on the sentence, and he was not required to do anything further. And he explicitly noted that on the record that he was not considering any mitigation evidence. And as for the new Norris error created in 2019, defendant is not adversely affected by which counts run consecutively to which, so the people submit that this court lacks jurisdiction to hear that part of his appeal, especially considering that defendant is serving lawful sentences that are authorized by the drug laws under Article 70, Penal Law 70. But additionally, because defendant is serving lawful sentences, we also submit that he should have been required to preserve his Norris arguments in 2019. But as to the merits, Judge Klott said that count 24 is to run consecutively to all of the sentences imposed. The language here seems to be mirroring Judge Whitner's last word on the sentence in 2007, where she said 24 and 25 are to run consecutively to each other. And that's what Klott did here. So no new Norris error was created in that his language specifically mirrors Judge Whitner.
Isn't count 25 supposed to run consecutively to count 24, but count 24 is supposed to run concurrently to all the other sentences? Isn't that what was supposed to happen?
Yes, Your Honor, that is correct, and that 25 was always supposed to run consecutive to 24. But here, Judge Klott said 24 and 25, 25 consecutive to 24, in that he was trying to mirror what Whitner said when Judge Whitner said 24 and 25 consecutive to all other sentences. But even if Your Honors perceive that that would be a Norris error, the court is in the best position to remedy that error itself. There's no reason to remand this case, there's no need for it, and the law does not require it. Nobody's in a better position than Your Honors.
Thank you, Counselor.
First of all, in terms of the reversal of resentence, the reversal, as it's very basic, means an undoing of whatever the judgment is. Here it's the resentence. So there's no way that a reversal of the judgment of resentence can be understood as being anything but a complete vacature of all the sentences. And proof of that is in what we call Javier 1 in the 2015, the court modified and remanded to correct on counts 24 and 25. So if the court wanted to modify and hold those sentences intact and just send it back, it could have done what it did in 2015. Now in 2019, with what we're calling Javier 2, it reversed and vacated. So again, he went there, he had no state sentences.
How do you respond to your adversary's point that, in fact, a hearing was held originally?
Right.
And that there's no well, or as my colleague, channeling my colleague, you don't get a third bite at the
I
hearing.
understand. That I was just going to get to that. Yes, we had the hearing in 2011, but because Norris came out 2 years afterward, and then the appeal was consolidated with the appeal from that 2011. That's an illegal sentence. You cannot take apart Norris. It's the entire sentence, right? If you look at this case that I cited, People v. Garcia from the Second Department, 170 AD 3 883, That defendant was properly sentenced under the DLRA. He's appealing to the second department, but he's got also a concurrent consecutive. And the second department says, we can't touch that because of Norris. We think that the sentence, the overall aggregate sentence is excessive. We can't touch the concurrent consecutive because of Norris, but we're going to lower the terms, and that's what they do. So you can't, so that's my answer. It's,
Thank you, Counsel.
you can't just take that out of the entire sentence.
Thank you. Channel Fabrics. You may proceed when you're ready, Counsel.
Thank you. Good morning. May it please the court. My name is Avery Samet of Amini LLC. I represent Channel Fabrics, the plaintiff. This is an appeal from the dismissal of plaintiff's accounting malpractice complaint, and we believe that was in error. Let me just get right to it. We believe the main ground for the dismissal, the lower court relied on the engagement letter and on the management rep letter, and we think the lower court misread those documents. Those documents, the standard is, they need to irrefutably rebut our allegations. And those documents say...
What is a review engagement?
A review engagement is an intermediate level of engagement for an accountant. The top
Would you
level,
concede that it's a lot less in scope than an audit engagement?
it is less than an audit?
A lot. Not just a less, a lot. There's a difference between the two.
Well, I'll go even further. An audit engagement, my understanding is, because I do these cases, the audit engagement is that the accountant has to go through the actual documents and verify whether the underlying client is telling the truth, but on review engagement, there are professional standards. And we've cited them in our complaint, we've cited them to this court. They have to apply analytical procedures. They have to give, and the language from the engagement letter is at docket 58, limited assurances, whether they're aware of any material modifications. And in the engagement letter, and this is my understanding of consistent with the professional standards as well, they will inform the appropriate level of management. Now, they cannot be relied on for fraud, but there is no evidence in this case, about Mr. Wolf, management engaging in fraud here. And that's the issue. Mr. Wolf, the president of this company, gave a management rep letter that said, to the best of my knowledge and belief, as of the particular dates of the particular ledger, of the particular letters.
Counsel? Neither the engagement letter nor the management representation letter express this point that the defendant's supposed to find fraud. There are a whole lot of representations or statements as to actually what's your responsibility. I mean, for instance, the engagement letter says, in paragraph F on page 50, and they're the same for each of the years, the accuracy and completeness of the records, documents, explanations, and other information, including significant judgments you provide to us for engagement. You're making a representation as to their completeness and accuracy. And the management letter, which you sent to the defendants, page 63, I acknowledge my responsibility and have fulfilled my responsibility for the preparation and fair presentation of the financial statements in accordance with accounting principles generally accepted in the United States of America. It sounds like you get very little out of this review engagement, and to say that they are supposed to find fraud. Oh, and there's also representation, again, that there are no uncorrected misstatements. To say that the defendants are under an obligation to find fraud is not really within these letters that cover the terms of service.
With respect, Your Honor, the defendants are under the obligation to advise us of material errors. I'm not saying fraud, of material errors. And that is in the engagement letter. That is in the engagement right at the front. The objective.
So in other words, I'm sorry. I was just going to ask you, with respect to the analytical procedures, what are the analytical procedures that should have been done to meet the criteria that you're citing?
All right. For example, in paragraph 39 of our complaint, We say that the defendants needed to compare the accounts receivable with comparable information from prior periods. They need to consider plausible relationships with accounts receivable.
Where does it say that in your engagement letter? I understand you say that in your complaint, but I don't see what the basis of that is in the engagement letter.
Well, the engagement letter states, Your Honor, on the first page that they need to do analytical procedures in accordance with SARS and the AICPA, and we've cited the court, that's what is required.
What establishes that that requires them to do the level of analysis that you're now claiming in your complaint they should have done?
That's cited in our complaint and in page 10 of our brief, Your Honor. That is the professional.
I know it's in your complaint in your brief. I'm asking for what documentation there is that that's their obligation.
But it's on the first, maybe I'm misunderstanding Your Honor's question. It's on the first page. SARS
When you look at the first page and you go to our responsibilities, paragraph B, obtain limited assurance as a basis for reporting whether we are aware of any material modifications that should be made to the financial statements in order for them to be in accordance with generally accepted accounting principles. It's whether they're aware. It's not even that you should be aware. It's just whether they're aware.
Well, but that is the professional.
It's a very weak standard that they have to comply with.
It is a weaker standard. It's not as weak as compilation, but it is a weak standard. But there are professional guidelines, and those are the guidelines that we're saying they breached. It's not. Otherwise, what's the point of these?
In answer to Justice Singh's question, you said that they were supposed to do for these analytical procedures, they were supposed to do some sort of comparisons between financial statements. And after all, the entity providing the information in those financial statements is you.
Yes.
And what would those analytical procedures have revealed?
Well, we say they were revealed. We say that for example, the accounts receivable and the accounts payable were grossly incorrect. We say that the financial statements for 3 years running showed profit of $7 million when there was loss of $3 million. We say that we didn't even have access to the financial information.
Obviously, somehow that was covered up, but how would the analytical procedures, how would a comparison of financial statements have revealed this? You can answer on, your time is up, so you can answer it on your response.
Thank you.
I'm sorry, did you want me to answer?
No, have a seat, have a seat. You'll answer in response.
I saw the red light was on, so.
See, the red light is for you folks, not us. We ask questions over the red lights.
Figured you can answer it in response.
Sure, Your Honor. May it please the court, Rachel Agassi, for the respondents. I'm just going to start with the question that you left off on, and that is a point that we make repeatedly in our respondents' brief and in the underlying papers, that they don't really identify what exactly was missed here, what comparison of whatever documents would have revealed this alleged deficit of $3 million. It's still, we're at the...
This comparison, is it more like an audit, what they're asking for, or is it more of a review engagement?
You are hitting on the points that Judge Cohen hit on during oral argument at length. If you look in the record of his questioning of appellant from 200 to 206, the transcript in the record, he goes through several revolutions of what exactly are you alleging here. And that is why when he eventually came out with this decision, he found that essentially their allegations sound in audit services, because what they ultimately allege, and it's the complaint at paragraph 40 in the record, it's page 20, is that the accounts receivable was not recorded by Channel Fabrics itself. They failed to properly record their own accounts receivable. So no comparison of the two documents of financials would have revealed this. And in a financial review, the only obligation is to see whether, when you're comparing the financials, whether it's plausible.
And they're responsible for misstatements. I mean,
Correct. Correct.
Both in the engagement letter and the representation letter.
Can you address the issue of causation here? It's not clear to me what causation...
Right, and that's why we find that we argue that Judge Cohen correctly found that proximate causation in this case are attenuated and speculative, because it really is unclear what the proximate causation is, because even if this comparison
Well,
of
they're saying,
financials, which they don't identify.
but for your negligence, they would have discovered this $10.3 million error.
Right.
Is that sufficient?
So what they're alleging is that somehow this comparison of financials, which they don't identify, would have revealed the error. The most that my client could have then done and is obligated to do in a financial review is make inquiries of management, not go to the vendors, not go to the clients, not find out the substantive basis for the accounts receivable. And they don't allege that my client didn't make inquiries of management, because they certainly did. I mean, that's a factual issue that they don't even assert. So how would it uncovered it? That's the proximate causation problem, that comparison
Well, I think what I heard,
Yeah.
at least what resonates to me, what they say is that, look, if we had discovered this error, we would have changed our business practices, maybe we wouldn't have taken out certain loans, given COVID and all that. Is that sufficient?
Are there damages sufficient for proximate causation? I think what you're harping on is another important point, that the damages here is a new damage model that really they don't find any support for. They're not alleging lost profits, because they can't. It was a failing business. They're not alleging that any creditors of the now allegedly defunct business are now seeking recovery. What they're saying is, we could have taken better business practices. And the cases that they cite in their brief that supposedly support damages are all instances where creditors are seeking recovery, which is not the case here. Instead, what they're alleging is, we could have sold things at a higher price, we could have taken less trips, we would have made certain cost-cutting measures that are always a good business plan anyway. So that's where the proximate causation problem is really highlighted. Even if the comparison would have somehow uncovered that there was this deficit, that they don't really identify, what exactly my client should have noticed. How the allegations that they could have taken certain cost-cutting measures is really speculative, and this court actually pointed that out in Leading Insurance, which is cited in the case. A similar account, that one was an audit case, similar accounting case, higher standards. But the damage allegation there was cost-cutting measures, and this court found that to be a speculative damage allegation. Seeing what else I have here. Oh, so, Your Honors really did point out the important point that I wanted to really specify here before Your Honors, but I think you have a good handle on it. The operative language is misstatements that my clients were aware of, not should have been aware of. That's the relevant language in the representation letters. That's the relevant language in the engagement scope. And this case really is limited to the engagement letters and the representation letters. Plaintiffs, appellants in opposition haven't put forth any affidavits, documents, anything rebutting that this was the scope of representation, and instead are trying to expand the scope of representation, and finding otherwise in this case, undoing the three elements that this Judge Cohen found that plaintiff failed to allege in this case: scope of representation, proximate causation, and damages, any one of which, if it was affirmed this case should still be dismissed, would improperly expand the scope of accountants in a financial review. Thank you.
You may proceed.
Thank you. Very briefly, one, proximate causation, this court has held, is a paradigmatic issue of fact. The duty, as counsel conceded, is they have to make inquiries of management under this review engagement if they find things that are warranted it. We've alleged specifically, in response to Justice Friedman's question, that had they looked at this, done these analytical procedures, that would have triggered the inquiry that they needed to make. That's what this claim is alleged. There's no heightened pleading here, and that's sufficient under this complaint. The documents that are referred to, they state, to the best of my knowledge. That's what the management rep is saying. Management is not aware of anything wrong with this, and that's true. And there's no evidence on this record that management was aware. And in fact, we've alleged in paragraph 21 and 37, we did not.
You agree, don't you, that they don't have to look behind the documents that you get, or that your client gives to them? They don't have to look behind them.
They don't have to look.
Is that a yes?
Yeah, but it's difficult to answer because we don't even have
a yes
the
and a
document.
no.
The answer is yes.
If it's a yes, then using analytical procedures, aren't you in asking them to go beyond that, to make these comparisons, to find that $10.2 million mistake?
Two responses. One, the complaint alleges they didn't have to go beyond the documents. And number two, the complaint alleges we didn't give them the documents. They created the financial statements. That's paragraph 21 and 37. They created the financial statements because we kept our books on a year-end basis for the tax purposes, and they made their own adjustments and modifications to extrapolate that out to the next year. They did not share that with us. They did their own review on those documents. In addition, I will just point out that the engagement letter also states that they engaged us beyond the guidelines, that they were going to assist our bookkeeper in adjusting the books of accounts so that they could prepare the trial balance from which financial statements can be reviewed. Page 59 of the record. So this, if I can just finish my sentence, the complaint is saying that, yes, it's limited, is not as limited as in the Darby case from last year, but it's limited. But even on this limited record, they had professional guidelines which they violated and which caused us to have the wrong financial statements, so we relied on.
Thank you, Counselor.
Thank you.
Happy Thanksgiving, folks.
Happy Thanksgiving.
CIT Group. You may proceed, Counselor.
Good morning. May it please the court. My name is Chris Carlson, and I represent the defendant insurers in this litigation. The central issue involved in this appeal and at trial was whether or not the insurance certificate relied on by plaintiff was sufficient evidence to establish, one, that the Fairfax policy that was a Brazilian insurer, whether it existed, what the terms and conditions of that policy were, and specifically and importantly, whether it was still in existence on the date of the loss. That was
So why not, based on the testimony by plaintiff of their custom and usage, the use of the certificate/endorsement document, the fact that there was no cancellation in accordance with the terms of that, why is that not sufficient to find that, in fact, that there was that particular insurance? Which is
it's
the
right back coverage, yes.
Yeah.
Well, several reasons, Your Honor. First of all, their custom and practice has nothing to do with the issue in this case. They testified that as a matter of business expediency, because it was too much work to bother to read all of the insurance policies. They had a whole fleet of aircraft. They didn't want to bother getting in hundreds of policies. It was too much work to read them. So as a matter of expediency, they decided to rely on the certificates. They said...
There's nothing in your policy, is there, that specifies how they would have to prove that they had right-back coverage? I'm a little, I'm not sure you can just say, well, they didn't feel like doing it. You didn't tell them what you wanted them to do, did you?
We said that we have an exclusion unless you can prove that there was an exception to the exclusion.
And they proved that by producing an insurance certificate which referred to itself as an endorsement.
Well,
but why is that not adequate proof, since you didn't define what kind of proof you needed?
Well, the problem with that, Your Honor, is that on the first time around in this appeal, the argument was made by plaintiff's counsel that this is an endorsement, it's contractual. Speaking of the certificate, they argued to this court, this is an endorsement to the insurance policy. It's a contractual document that confers rights on the insured. This court, after considering that argument and having the very certificate in front of it, said, no, it's not. It's not a contract.
Well, I'm sorry, go ahead. No, I disagree with that. We did not, we referred to the certificate, but there is clear endorsement language on pages 2 and 3, which we did not address in that prior decision. So going back to the endorsement language, it says specifically about hull and hull war insurance. And then you can look back to the certificate where it discusses the hull all risk and aircraft engine insurance. Isn't that enough based on, as my colleague pointed out, there's no requirement that the actual policy be produced?
I don't think so, Judge. And for two evidentiary matters, as an initial matter, as we pointed out in our briefs, we believe that this should not have even been admitted under the best evidence rule and on the hearsay.
So let me stop you there. Let's deal with the best evidence rule. If the, as my colleague says, if the policy doesn't have to be provided to establish the hull risk insurance, why is the best evidence rule even implicated with respect to the missing policy?
Well, they have to prove what the policy said. And in this case, the policy was the central document in the case. It was disputed. We disputed that it was issued, what it said, and particularly—
Well, let's go back to that. When did you actually dispute, when did you actually even request a policy in this case? Because the email exchange, which goes to your second evidentiary point, seems to suggest that you weren't really looking for the policy.
Well, it is, plaintiff is correct. We didn't serve a document request asking for it. We asked for it twice in deposition. Once of the deposition of the insurer's corporate representative, he asked specifically twice, let me see the policy. They said no.
But before the lawsuit, was there ever any time then you requested this document?
You're referencing the September 2016 emails where I think it was your adjuster. It doesn't make that kind of request.
Before the lawsuit was filed, the whole dispute between insurers and CIT was about the policy year in which this loss fell. And we were taking the position that it fell in the 2012-2013 policy year, which didn't even have, this exclusion wasn't even involved. So at that point, there was no reason to ask for that. I see I'm on.
No, you got 2 minutes.
Yeah.
Okay.
But at the end, this issue is, this becomes a factual issue presented to the jury. And the jury answered the question against you.
Well, I respectfully, I don't think it was a question to put to the jury in view of this court's ruling that this was not a contract. What they did not walk into court and say, this is evidence that the Fairfax insurance company intended to issue this policy. Their witnesses came in and they said two things. First, they said, this is an endorsement. This is part of the policy. It's a contractual document which actually confers the right back coverage. Now, that was over our objection. We filed a motion to eliminate to prevent them from saying that based on your ruling.
Counsel, if we disagree with your interpretation of our ruling, what's your alternative argument?
I'm sorry, Judge?
If we disagree with your reading of our decision, what's your alternative argument?
Well, they also—
They who?
I'm sorry, the plaintiff, not only they were saying that this actually is a contractual document which confers rights, which it's not. No court in New York has ever held that an insurance certificate is a contract.
But I want to stop you there, and there is some pushback. The document that you refer to as a certificate is both a certificate and an endorsement, and the question in my mind is there, as my colleague suggests, this is a document that went to the jury, each side made their arguments, and the jury agreed that such insurance was taken out, essentially based on this document. Why is that not the end of the inquiry? It's not an irrational decision.
Because I don't, respectfully, Judge, I don't see how it can be a contract that confers coverage if it's not a contract.
Well, isn't it signed on page 3?
Yes, Judge, it is.
So isn't there contractual language? It's an endorsement.
Well, I have to go back to it's a certificate, and the case law says that that's not a contract. It doesn't confer rights.
It's not your typical certificate, is it?
I'm sorry, Judge?
It's not just typical certificate, is it?
It's not, Judge.
I've never before seen a certificate that says in its body, this is an endorsement. Doesn't that change things?
Well, no, because, going back to the case, at the top of this, it said it's a proposal. And we had an argument in the papers about whether or not they argued that this is different from the usual accord form, which has disclaimer language across the top that says this confers no rights. First of all, as we pointed out in our briefs, there is no case in New York, at least that I'm aware of.
When you look at the certificate that covers 2014, what it says, this is to certify that the aircraft described above is insured by this insurance company.
But that follows proposal. Proposal modifies everything. It's up in the second line at the top on the left. So this is disclaimer language, just like an accord form.
You mean you're pointing to the fact that it uses the proposal and then has an identifying number with year?
I'm sorry, Judge.
Your whole reliance is the fact that it says proposal, which is contradicted when it says this is to certify a little bit lower down, is insured.
Well, I don't think so, Judge, because they're saying this is what we propose to issue. And plaintiff's witness testified that.
So why would you use the language, this is to certify, is insured? This is to certify that the aircraft described above is insured. If this is just a proposal, why would you say is insured?
This is what they're proposing to issue, because this precedes the actual issuance of the policy. And plaintiff's
Well, wouldn't that
witness,
be more consistent to have language like "we will then insure" as opposed to "we're insuring"?
they're saying this is what we're proposing to issue.
But that's not what that's not accurate in terms of what it says.
But
again, these are issues, these are arguments I'm sure you made before the jury, no?
Yes, but
So let's go back to sufficiency. I mean, or Hall versus Cohen versus Hallmark. I mean, how do we upset this jury trial? There was a jury trial, not a motion for summary judgment, a jury trial.
and I have to go back, Judge, to this court's ruling.
So
that
law
this
of the
is not a
case,
contract.
law of the case, essentially.
Right. If I could, Your Honor, the second.
I'll give you a couple of minutes extra, but let your adversary speak.
Good morning, Your Honor. Robin Michelson on behalf of Respondent CIT. We request permission for Mr. Safa, admitted pro hoc vice, to argue the appeal.
I assume there was a request filed originally?
Yes, Your Honor. It should be with the notice of appearance. We have another copy.
Okay. Yeah, the motion's granted. Counsel?
May it please the court, Omid Safa on behalf of Respondent CIT. Your honors are absolutely correct that this is a factual issue. It was presented to the jury for 4 days. The jury heard all the evidence, saw all the exhibits. CIT, frankly, put on all of the case, all of the exhibits.
So how do you respond to your adversary's point that, in fact, our prior decision is law of the case? We said it was a certificate. There's no question we said that in that. Why shouldn't we follow our case and say that this document as a matter of law is not sufficient?
It's not law of the case, Your Honor, because in the previous decision, this court did not seek to determine the factual significance of the Fairfax certificate, and the court never reached the issue of whether or not it was, as a matter of fact, an endorsement. And there was no reason to address those issues, and there's two reasons for that.
We said that it did not conclusively establish that a contract exists, right?
Correct, Your Honor, correct. But the posture of the case at the time is important, and then later on there's an admission by the insurers during the appeal in their reply that is also important. In terms of the posture, this court was considering the trial court's grant of summary judgment. And when you review that trial court decision, you'll see that it was never based on whether the Fairfax certificate was or was not an endorsement. The word endorsement never appears. And there's a reason for that, because it was a disputed issue of fact at the time. The insurers were arguing, no, this is not an endorsement. It's just a certificate, run-of-the-mill certificate. You can't rely on it. So we had a disputed issue of fact. The trial court, looking at the certificate, treating it as an insurance certificate, given that we have a factual dispute how far it goes, still granted summary judgment. That's how it was teed up for this court. When this court addressed the issue of whether a certificate of insurance is sufficient in itself, it remanded the case back. This court never went further to try to determine, as a factual matter, is the Fairfax certificate in this instance an endorsement? Did it go further?
I mean, you would say we left it as an issue of fact, but you prevailed on below.
Yes, Your Honor. Yes, Your Honor. And this court certainly did not preclude CIT from presenting evidence like course of conduct, the development of the template
What's
certificate.
your response to your adversary's argument that it says proposal on top?
So this is an issue that was presented throughout the trial. The jury heard all of this. It's not a proposal. One of the items identified on the certificate is a proposal number. As you would have with an invoice, just because you have a prior purchase order number reference on the invoice doesn't transform the invoice into a purchase order. It's just a proposal number that was listed on the Fairfax certificate. And we also see the course of conduct in terms of the negotiations with the insurers, changing the values of the insurance. For the 2014-15 policy year, which is the relevant year here, initially the certificate was issued with a $2.1 million value. CIT said, no, that's not good enough. Please raise it to 2.8. Fairfax reissues the certificate, signed and initialed by its representatives, and including all the language that was based on the CIT template endorsement. And the reason why CIT insisted on having an endorsement modeled after its template is because it wanted something that it could rely on. It didn't want a run-of-the-mill certificate that says, for information purposes only, confers no rights. It wanted something that becomes part of the customer's insurance policy and that will control with respect to the terms that it addresses. That way, it has the document that it needs.
Certainly you created some confusion by referring to the document as an insurance certificate.
Ideally, it would have said endorsement on every single page. The insurers have argued now, as they did in the reply during the first appeal for the very first time, they say, okay, fine, pages 2 and 3 are the endorsement. Forget about page 1, don't read the document as a whole. But as you said, Your Honor, that doesn't make sense when you look at the document, because on the first page you have, for example, 2 types of hull coverage that are referenced.
And I'm assuming hull coverage is a term of art. It's not just,
Yes, Your Honor.
So when they see that, they know what it's referring to.
Absolutely, Your Honor. So you have the basic hull, which is hull all risks, and then you have the hull war, which includes the confiscation for government of registry.
So now in the endorsement part, point 1, it does reference the hull and hull war insurance.
Absolutely, Your Honor.
And so it's your position, I assume, is that we should read this language in the endorsement with what the certificate says, or more importantly, that's what the jury saw.
Yes, Your Honor. It should be read as a whole.
Counsel, can you just address something different, which is the argument that those emails were inadmissible hearsay and should not have gone to the jury for consideration?
Your Honor, so there were multiple reasons why it was admissible. One was it was established that those email communications were business records. The foundation was laid by CIT witnesses.
Wasn't it a party admission?
So there are multiple types of emails, but so there was another email from the insurance adjuster requesting a slip or an endorsement as proof of the coverage. And that, yes, was a statement by a party opponent. It's not hearsay. It's admissible, highly probative of what the insurers actually wanted rather than the extra contractual limitations they're trying to impose now.
Thank you, counsel.
Your Honor, if I could just touch briefly on 2
If I could
points.
just take you back to, so your point to proposal, and I read to you about this is to certify, isn't what we have then, looking at best case scenario for you, there's a conflict between the 2 statements. So it creates an ambiguity, which if you're asking for us to determine something as a matter of law would be interpreted against the one who drew up the document, which would be against your client's
I'm sorry, Judge, I missed the beginning. You're talking about the certificate of
proposal. You point to proposal and say, this is not insurance.
It's not my document, Judge. We insured their fleet of aircraft. Our policy said we'll cover.
You've got to have
the
hull and war
lessee
insurance in order to get.
has to get separate insurance. So this was supposedly issued by the Brazilian insurance company, had nothing to do with me.
So it would be interpreted for the if you're left with this conflict between the two provisions, wouldn't it leave you that you should say that there is insurance by whoever issued this?
But we didn't even know this existed. There was no reason for us to know it existed. And if I could get back to the proposal issue, they've tried to explain it away. But the simple fact of the matter is their witness admitted during trial, she did not draft this. No one at CIT drafted it.
Well,
They
counsel,
never
all
even-
that goes to weight. That goes to weight, and the jury heard, I'm sure, over and over what your characterization of this document was and what plaintiff's characterization. And unfortunately for your client, they agreed with plaintiffs. How is that irrational? How is that based on this certificate?
It's total speculation for them to say when whoever wrote this, when he wrote proposal, he meant something else. And they were saying that this proved the insurance that was provided by the absent
It's
insurance
not just
policy.
this, it's not just the first page of the, which is a certificate, granted, but it's pages 2 and 3, which is an endorsement and does specifically refer to the Hull and Hull War insurance.
It does. It says what it says, Judge.
Yes. So
All
those
under-
issues were
all
before
under
the jury.
proposal.
Those issues were before the jury. It's not a motion for summary judgment. Those issues were before a jury.
I submit, Judge, respectfully, it never should have gotten the jury in view of, or they never should have been able
Well,
to
we should have
give the
granted your motion
testimony.
for summary judgment.
That's a little bit late for that, isn't it?
We left it for a jury to determine it. I mean, our prior decision made this a factual issue.
Well, we tried to keep it out. We filed the motion and eliminated. The judge disagreed with us. But if I could move on to just another equally important point. Their burden of proof was to, number one, prove the policy existed in its terms and conditions, and specifically, they had to prove that it was still in existence on the date of the loss. Now, it is undisputed that the lease was terminated, the aircraft was taken back by CIT, and then 4 weeks later, while CIT still had the aircraft, that's when the loss occurred. The lease agreement provided that the lessee, Saban, had to provide the insurance during the term of the lease. They agreed the lease term had ended.
So you're saying that 4 weeks there was no insurance?
Okay, well, that's just sort of background to what I'm going to say next. As I said, they needed to prove that it was still in effect on the date of the loss. And their proof issued on that, or that they offered on that, consisted entirely of Section 3.6 of the insurance certificate and the testimony of their corporate representative who said, we expected and wanted to be given notice pre-cancel.
Well, is it an expectation or is it a contractual requirement that they be given?
We
30-day
don't know, Judge, because if you look at 3.6 in the insurance certificate, it says, and this is specifically what they referred to, it says, except in respect of any provision, except in respect of the cancellation and automatic termination provisions of the policy, they were entitled to notice of either 30 or 7 days, depending on what happened. The qualifying language, except as provided in the cancellation and automatic termination provisions, raises the question, was notice required under any circumstances? 1 day notice, a half an hour notice. We just don't know. I questioned their witness extensively about this at trial. She admitted that the insurance policy would have had cancellation and termination provisions, but she said, I don't know what they said because I never read them. I never even saw the policy. Now, she tried to explain it away by saying, in my experience, number one, we always expect it. In the lease agreement that we signed with Saban, the lessee, who we're not a party to, we asked for it. And in her experience, she said, generally aviation policies, the only time that they provide for cancellation with not notice is a World War III type scenario where everyone knows that the world's blowing up and we don't need it. That doesn't prove what this contract said. An insurance policy is a contract. The parties are free to negotiate whatever they want. Because they chose to prove or to attempted to prove or meet their burden of proof of showing that the policy was still in existence on the day of the loss by saying, we expected to receive notice, but we didn't receive notice, So we assume that the policy remained in effect. That's not good enough. Everyone in the courtroom, me, them, the jury, the judge, was left to speculate as to whether or not the automatic cancellation and termination provisions in the policy required notice, some notice, under all circumstances. Now, the fact that many aviation policies may allow for cancellation without notice in World War III situations is meaningless, because there is no single worldwide requirement that every aviation policy is worded in the same way, and they all have the World War III is the only situation. In fact, what we pointed out as an example is that our policy would automatically terminate without notice in the event that they sold the aircraft during the policy period. It's the same thing. I don't know what it said, okay? I'm speculating.
Okay.
But it is not an unreasonable speculation to say that when the Fairfax issued a policy to insure this company that was leasing the aircraft, only because they were leasing it, they were operating it, they were controlling it. Now, the lease ends, they lose possession and control, the insurer has no idea where it is, who's handling it, what's happening to it. Common sense would dictate that the terms of the policy would say something like their policy said, once you no longer have an insurable interest, the policy ends, and we don't have to give you notice. Now, I admit that's speculation, but I didn't have the burden of proof on this. They did.
Thank you, Counselor.
Thank you.
No, no. $255, ADC Realty. You may proceed, Counsel.
Good afternoon, Your Honors. Constantine Baltzis for the appellant, the landlord. This is a landlord-tenant relationship, basically.
Is there no dispute on this record that the violation that was issued against the building in March of 2011 for the signage
Correct.
was, and there's record evidence that it was resolved that same year by ECB, the payment of the fee, et cetera. So then, when we have an action in 2019, that kind of triggers the statute of limitations question. Is there, do you have any doubt as to the timeline in that regard?
The doubt, there isn't any doubt as to that, looking at it in the vacuum. However, simply paying for the fine doesn't correct the condition. It just creates a recurring event for the DOB to come in, issue more violations, which would escalate.
But but that didn't happen, did it?
I think a violation issued, it's in the record, it was issued after we started the lawsuit in 2019.
But you can't rely on that violation that occurred after you began the lawsuit as a way of getting around the statute of limitations, right?
I can't rely on it in that instance, Your Honor.
So how do we, what extended the statute of limitations?
The fact that the tenant took absolutely no action to correct the condition.
But isn't that essentially a continuing effect of the original wrong? It's not a new wrong that's been committed. They didn't do what they were supposed to do back in 2011. They paid fines, but there are other things to do. And the effect is, in 2019, we get another violation.
There was another violation, correct,
Sure.
Your Honor?
So, but I'm asking you, is that a continuing wrong, or is that the effect of the original wrong? Because if it's the latter, then you're out of luck.
It is a continuing wrong because they continued for years upon years of not complying with the lease.
But what was the wrong?
The wrong was initially filing the signage incorrectly.
Which resulted in the violation.
And then failing to cure it and refusing to cure it, Your Honor. The condition is still illegal, and my client should not just sit there and wait and say, I paid the fine in 2011, and now I'm fine. There's no waiver on the landlord's side, and my client actually is the sublandlord.
There was also a lease renewal.
There was a lease renewal simply because the overlandlord wanted to have a direct relationship with the tenant. We got out of this relationship, but we were stuck in a position where we had to legalize because we risked our lease being terminated because the condition was not being corrected at all by the tenant. And then the landlord told us, the over-landlord told us, just enter into a direct lease and then step away. And that's why we stepped away when the lease was renewed.
How
Was-
is it that there's evidence that it was cured, and you're saying it's continuing, including after you filed the original complaint?
It wasn't technically cured. What we did was we paid the violation fee. And then over the years, we continued to do work both with LPC, DOB, in order to address all of their objections in the process of curing the condition. Signage was put up by the tenant, and every time that we tried to file papers to legalize the condition, DOB came up with their own defects list. So did LPC, Landmarks Preservation Commission. So it took us years. And in between that time, there was a fire in the building. So dealing with all of the
That
issues,
was in 2014. The statute of limitations is run on that too.
the statute of limitations, if you looked at it from 2011, it would have lapsed in 2017. But we had an intervening fire.
You can't rely on the fire either.
We're not relying on the fire. I'm just explaining to the court why it took us so many years.
The building was a mess, essentially, is what you're saying.
I don't have any personal knowledge of that, and I don't want to say the building was a mess. I don't want to disparage the current owner or not, but there were problems with the building that we were trying to address.
What is the impact of the fire on the statute of limitations?
I'm only responding to Your Honor's request or inquiry why it took us so long to cure the condition.
I see.
The question that was presented was from 2011, you guys paid a fine. Why did it take so long to cure it? Well, we had an intervening fire related directly to the tenant's furnace that caught on fire. And we're there with the dustpan and the broom trying to clean up the mess that a tenant who knowingly knows that they're supposed to comply with law and they continue to refuse to comply with law. And I believe the decision that we cited in our reply papers, Tuck It Away, deals with a very similar situation. A violation that occurred years ago. It was brought to the court's attention and there was no waiver found. The continuing wrongs doctrine was applied, and the tenant was I think, ultimately evicted. Thank you.
Thank you, Your Honors. Please the court. Himmelstein, McConnell, Gribben, and Joseph for the defendant respondents. As Your Honors correctly point out, the complaint focuses on a violation that was issued in 2011. In that same year, it was recorded as being cured. 9 years later, they bring a lawsuit. The statute of limitations clearly ran. There's nothing in their complaint that alleges that the cure of that violation in March of 2011 was erroneous or faulty.
Your adversary, can you respond to the case cited by your adversary? Your adversary says that the Tuckaway case essentially is similar to this case where there was a continuing wrong.
Yeah, but here, though, there was a cure, though, that was recognized by the Department of Buildings as resolving that violation in its entirety in 2011. Well, many, many, many years after the statute had run, but before they started this case. And that's a distinction. There's nothing in their complaint that speaks to anything that violation was ongoing or continuing at all. Nothing at all.
Argues that it was actually your obligation to fix it, and that therefore it was a continuing wrong. Why isn't that right?
That's not right. Also,
Can you explain why that doesn't apply?
it doesn't apply because here the act itself happened in 2011. There's nothing that would have prevented them from filing a cause of action within the statute of limitations period. Nothing at all. And their attempts to sort of extend this out because of a fire, et cetera, is misplaced.
Thank you.
Thank you.
Counsel? 2 minutes.
Thank you, Your Honors. To say that the violation was cured, would then defy why the Department of Buildings and LPC, Landmark Preservation Commission, issued objection letters. They would say to us, well, you cured it in 2011. What are you still doing here, filing papers with us? That's completely erroneous for the tenant to continue to argue that.
But the question is whether that's a continuing wrong or is that the original wrong cured And then what occurred after that was the effect of that wrong.
There was never a cure, first.
There was never a cure?
If there was a cure, what we did was we paid a fine. What the landlord in this situation did was we paid the fine with ECB, the Environmental Control Board. After that, there was no cure. In order for us to cure, we had to file papers. We filed papers under penalties of perjury that were trying to cure the signage violation. We're trying to legalize the condition, a condition that was prompted solely by the tenant, its alterations, and the tenant never took any action, any corrective action whatsoever. Technically, the continuing wrong doctrine then would be eviscerated if we only just look back at 2011. We have to look at the effects that it had. And every day of the lease term that the tenant failed.
But under the case law, effects is not sufficient. It has to be, there has to be a continuing wrong, i.e. it's a violation.
Ultimately, practically, became a continuing wrong in that we see in 2019 a violation was indeed issued by the Department of Buildings several years later for the same condition.
Thank you, Counselor. Happy
Thank you.
Thanksgiving to you folks.
Happy Thanksgiving. Jesse, nice to meet you.
Pleasure. I've seen you around in Housing Court. I never met you face to face. Good to meet you. Listen, appreciate that.
Say hello for me. I'm sure you're going to get together with him.
Oh, definitely, yeah.
He's made good money on apartments.
Yes, yeah.